Hey, what's up? Welcome to Becoming a State National. I'm not an attorney, and by no means is this legal advice. I'm just some guy who's regurgitating information I came across that I think a lot of people would like to hear. So, this is part two of how to beat a traffic citation using the common law. And we are on to chapter one. So, let's just get into it. Not many people realize it, but when you are faced with going to court, you, in many instances, have a choice of which system of law that you wish to have jurisdiction over you. You just have to know how to insist upon one system of law as opposed to another, and how to rebut the presumption that a contract, which would limit the choice of law, is in play. In order to retain rights recognized by the Constitution, meaning certain unalienable rights as described in the Declaration of Independence, you need to be able to enter a judicial court of record under the common law and stay out of the legislative administrative court such as are found in traffic court. In the case of traffic violations, the system that you want to stay out of is the system that is bringing you into court in the first place, the legislative statutory system of law. This can be either a county justice court or a city municipal court, which will adjudicate the Department of Transportation traffic codes in your state. In either instance, these are not, as many people mistake them to be, judicial courts. Rather, they are administrative courts. Administrative courts administer the law. In other words, the way they operate is cut and dried, and based on assumptive or presumption of your identity and its connection to the subject matter at hand. Unless you know what you are doing and what is happening, whatever defense you put up that is based on the understanding that you are in a judicial court will be pointless and ineffective. That is, you are entering a losing battle. Administratively, since you consented to identify yourself as a licensed driver and did not rebut the fact, the court sees you as bound by the license agreement or constructive trust by the operation of law, which is that you must follow the traffic codes to the letter or suffer the consequences of not having done so. When there is no dispute over the facts in such a case, you are presumed guilty and must suffer the penalty if you are unable to prove yourself innocent. In an administrative court, the burden of proof is switched to the defendant. This is how these courts prevail in the majority of the cases brought before them. It's like leading unaware lambs to the slaughter, and generally results in the instant revenue for the city and state holding court. In order to stay out of the jurisdiction of the administrative traffic courts, you have to challenge jurisdiction, for example, through proof of a reservation of rights when you sign the traffic citation. Administrative courts deal with only fictions in law. They don't deal with natural people, meaning flesh and blood human beings. Legal fictions can bring action against only other legal fictions. Therefore, you have to agree to be representing yourself as a legal fiction in order for this type of court to gain personam jurisdiction over your person or legal person. Natural people can bring actions against only other natural people. This is partially what is meant by the phrase equal protection under the law. Only alike parties or consenting parties to the jurisdiction may bring suit or complaint against one another. A person representing himself as a legal fiction cannot bring a complaint against someone not claiming also to represent himself as a legal fiction. Both parties must be of the same legal makeup or capacity and in agreement regarding the type of law being used. By reserving your rights as a natural man or woman, and not a legal fiction as the entity is identified on the driver's license, you effectively challenge the court's jurisdiction. But you'd better know how to explain this, or if you find yourself in court, the judge will trick you into consenting to his jurisdiction. And in many instances, you won't even realize that this has happened. The court needs to meet the test of jurisdiction in two ways. It needs both subject matter jurisdiction as well as personam jurisdiction. That is, in order to hear the cause at action. The court must be able to hear cases on the subject matter at hand as well as have jurisdiction over the persons involved. And the subject matter must be evidenced, sworn testimony, on the record of the court when the prosecutor first files the case with the court. If there is no sworn evidence in the filing paperwork, the prosecutor has not properly set the court's subject matter jurisdiction, and the case can be dismissed. If either of these two jurisdictions is not in place, a court must recuse itself of jurisdiction and dismiss the case. When you insist on identifying yourself as a natural man or woman and properly rebut the court's assumption with admissible evidence of such, you retain your identity status as a non-fiction at law, thus forcing the court to recuse its in personam jurisdiction. A brief but important note, which will be expanded upon in later chapter, about the terminology being used in courts. When you consent to appear in court, every detail about what you say has a legal significance before the court. Most lay people are unaware of this fact. They naively believe that the words they use, their definitions, are commonly understood, and that everyone understands their meaning. However, in court, if you are unaware of the legal meaning of a seemingly innocent word you use to describe your cause, then you can inadvertently be admitting to something to which you did not intend to admit. The legal system and its statutes had commandeered, redefined, certain words and phrases such that they no longer mean what most people think they mean. The words person, natural person, and individual are all examples of this practice. These have been redefined in the statutes to include legal fictions, generally to entrap the unwary. So, unless you have read through the statutes in order to ascertain the meaning of certain key words you may be inclined to use, if you want to make clear to the court that you are presenting yourself as a natural person and not as a legal fiction, use the terms natural man or natural woman, or better yet, private person, who is made up of flesh and blood, in order to make your point. Once this distinction is on the record, it can seemingly throw a monkey wrench into the proceedings. More about how to get this on the record in a later chapter. This can effectively remove personam jurisdiction from the administrative court. However, and this is a very important however, this objection must be done at the very outset of the matter before anything else in the matter is discussed, meaning before an arraignment hearing takes place. The officer who issued you the citation is representing a fictitious public entity, either a municipal city or state county, and therefore is coming at you as a legal fiction at law. Once you successfully identify yourself as a natural man, the only legitimate way the officer can come against you is as a natural man himself. In order to do this, he must have a corpus delicti, that is to say, the body of a crime, or an injured party. If he has no one to swear out an affidavit of injury, he has no case. This is because a corporation, in this case the state or city municipality, cannot be the body of a crime or an injured party because it is artificial, a fiction. It doesn't exist. And so how can a crime or injury take place? No corpus delicti, no case, it's that simple. For example, if the cause of action is that you were doing 50 in a 35, yet no one was harmed or injured by that is, no accidents took place, then there is no corpus delicti, no injured party. This being the case, there is no cause of action or claim because the state does not have a standing as an injured party in common law. Only in an administrative court where legal fiction is coming at legal fiction in a cause of action would the state, as a legal fiction, have standing. It would have standing through the constructive trust obligation of the driver license, wherein the driver agreed to play by the rules of the traffic code. The point to take away here is one involving proper identity and proper jurisdiction. If you do not identify yourself as part of the class of people who must obey the traffic code, and if there is no injured party involved in the infraction, and you challenge jurisdiction by successfully rebutting the presumption that you are a driver. Driver is a legal word of art used to delineate someone operating in commerce or compensation or pay. Then, the administrative court has no choice but to recuse itself and drop the matter. By rebutting the court's assumption that you are a driver, you place the burden of proof back onto the state or city municipality to prove that there is a contract in play that preludes your rebuttal. They have to produce the contract which you signed and entered into evidence, or come up with a verified complaint, in essence a corpus delicti, proving an injured party exists. However, it is unlikely they will be able to accomplish either of these two things, because essentially neither a valid lawful contract with your signature on it nor a sworn complaint exists. Therefore, the case must be, or should be, dismissed. Yet beyond these technicalities of law, if you understand your natural rights to travel on the roadways of the country and in what context this right is upheld, then you may never fear a traffic stop again. We will take a look at this right in more detail in the next chapter. So that's chapter 1. Make sure to follow and like so you can see chapter 2. So yeah, and also if you'd like to get a packet to change your status to American or State National, shoot me an email at help@becomingastatenational.org. I can send you information, and from now until the end of the year,